Good evening and welcome to this public briefing of the Standing Committee on Social Development. My name is Jane Wayalin Armstrong. I am the MLA for Mofi, Clutha Region, and chair of this standing committee. At this time, I will ask committee members to introduce themselves, starting from my left.
Good evening, welcome. My name is Danny McNeely, representing the Satu region.
Good evening. George Nersu, MLA for the Mackenzie Delta.
Hi, I'm Shauna Morgan, MLA for Yellowknife North.
And we have two online. Can you please introduce yourself?
Hi, I'm Cheryl Yakla. I am a member for the Det'anchogh. Thank you. Welcome.
And I am Kieran Testars. I am the member for Range Lake here in Yellowknife. Sorry I couldn't be there in person. I'm home with the kids tonight.
Okay, thank you. Bill 45, Civil Forfeiture Act, received second reading in the Legislative Assembly on March 5th, 2026. Bill 45 proposes to create a legal framework for the government of the Northwest Territories to be able to apply to forfeit property that are proceeds or instruments of unlawful activity with the goal of disrupting the flow of money from criminal activity. This committee has been tasked with reviewing the bill to see if it needs any changes. If it has any issues, we can solve, and if it is ready to continue on its path to becoming a law. That is our role in this process. We did not write the bill, but we are in charge with taking a very close look at it and making sure this bill represents the wants and needs of residents as best we can. This evening, committee will receive a briefing from the sponsor of the bill, the Honorable Minister of Justice, to learn more about how Bill 45 works. At this time, I would like to turn the floor to the Honorable Minister of Justice. Please proceed.
Thank you, Madam Chair and committee. Certainly a pleasure to be here tonight. I'd first like to introduce the staff that's with me tonight. Brad Patzer, Assistant Deputy Minister, Attorney General, Department of Justice, and Adrienne Schmalz, Legal Counsel, Department of Justice. I'm pleased to be here today to discuss Bill 45, the Civil Forfeiture Act. Civil forfeiture is designed to recover the proceeds of unlawful activity as well as property used to facilitate unlawful activity. The purpose of civil forfeiture is to make crime unprofitable and to make any resources related to the commission of a crime unavailable to fund future crime. Civil forfeiture can also help compensate private individuals and public institutions for any cost they may have incurred as a victim of a crime. I have a short presentation that will outline a little more information on the proposed legislation, its purpose, and what it contains. This concludes my opening remarks. After the presentation, I would be pleased to answer any questions members may have regarding Bill 45. Thank you, Madam Chair.
Okay. Thank you. Please proceed with your presentation.
Thank you, Madam Chair. The presentation we've developed is split into three parts. We have an introduction, some comments on the development of Bill 45, and then several comments on the overview of the legislation itself. By way of introduction, civil forfeiture is designed, as the Minister indicated, to recover the proceeds of unlawful activity as well as the property used to facilitate unlawful activity. These are known as the proceeds and the instruments as referred to in the legislation. Civil forfeiture exists across the common law world. It's common in Australia, New Zealand, Ireland, and the United Kingdom as examples. There are other countries outside of the Commonwealth that have also adopted civil forfeiture, like the United States, South Africa, and the Philippines. The Northwest Territories bill is based on that of the other Canadian jurisdictions that have already had the benefit of learning from civil forfeiture regimes from around the world. Just a note on the terminology that we've used. The GNWT civil forfeiture uses the term civil forfeiture, but other places describe civil forfeiture as civil asset forfeiture or non-conviction-based forfeiture or asset forfeiture. How it works? The government will bring a proceeding against the property rather than the individual, which helps distinguish the process from the criminal law process, which is a prosecution against an individual. On the slide is a quote from the Supreme Court of Canada, who unanimously held that the Ontario's Act was constitutional. Chatterjee was the name of the case, and it remains the seminal case in Canada where all three levels of court rejected Chatterjee's arguments. The arguments made in that case were that only the federal parliament had jurisdiction to pass this kind of law. The criminal law standard of proof, beyond a reasonable doubt, ought to apply, and that there are irreconcilable operational conflicts between civil forfeiture and the criminal law. As indicated, the Supreme Court of Canada rejected all of these arguments. The department's policy work on the bill started with a jurisdictional scan from the other 9 Canadian jurisdictions with civil forfeiture legislation. From that scan, we identified that both BC and Manitoba as the leading jurisdictions. We connected with other provinces in our research and Nunavut for virtual meetings. Staff attended the National Civil Forfeiture Committee Annual General Meeting in October of 2025, and also the National Civil Forfeiture Litigators Virtual Conference in February of 2026. Following the approval of the legislative proposal, we began public engagement on civil forfeiture. There was an online survey, online meetings, and in-person meetings as well. There were books and articles that were reviewed, in particular by one Jeffrey Simser, who is a leading expert on civil forfeiture in Canada, and that has been a valuable resource for us as well. By way of overview of the bill, the Act is structured into 6 parts. Part 1 sets out the introductory provisions, including definitions and purposes. Part 2 addresses civil forfeiture orders. Part 3 establishes the administrative forfeiture process. Part 4 addresses the conduct of proceedings and presumptions. Part 5 deals with the financial and administrative matters, and Part 6 deals with miscellaneous provisions. Throughout the presentation, I'll refer to frequently the director, which means the director of civil forfeiture, and also the asset manager. These are 2 statutorily appointed positions under the Act, but I won't discuss the actual positions until Part 5 of the presentation. Aboriginal and treaty rights. The department completed a consultation assessment and determined that the legislation itself, as a law of general application, did not trigger any consultation obligations. For additional certainty, however, the Act includes a non-derogation clause, which does the following. It signals that civil forfeiture is not intended as a backdoor way of eroding Aboriginal or treaty rights. The requirement that actions under the Act be carried out in accordance with any applicable land, resources, and self-government agreement gives practical guidance to the director and asset manager and nudges them to check the relevant agreements before proceeding with cases that might impact Aboriginal or treaty rights. The conflict rule in favor of land, resources, and self-government agreements and their implementing legislation provides simple built-in ways for courts to resolve conflicts without engaging in a full constitutional challenge. The Act also presumptively protects certain classes of interests, like banks, insurance companies, and governments, explicitly federal, territorial, and municipal governments. Although Indigenous governments and Indigenous organizations aren't explicitly included right now, the Act allows for a similar class of holders to be prescribed in the regulations, which would allow the department to update the list of presumptively protected Indigenous government organizations that hold property through land claim agreements and Indigenous governments recognized through self-government agreements, all of whom can be presumptively protected. The list can be updated as new agreements are finalized in the territories. As an example, under the Nunavut's Unlawful Property Act, that act presumptively protects a designated Inuit organization as defined in the Nunavut Land Claim Agreement with respect to Inuit-owned lands vested in that designated Inuit organization. The Act, as most do, includes a definition section. Key definitions include property, which is broadly defined to include real property, like land and buildings, and personal property, like cash, vehicles, cryptocurrency, and other valuables. Unlawful activity is defined to include offenses under territorial, federal, and other provincial legislation, as well as offenses from foreign jurisdictions if there's an equivalent offense in the Northwest Territories. The other key definitions are instruments and proceeds of unlawful activity. Each civil forfeiture proceeding must be brought on the basis that the property in question is either a proceed or an instrument of unlawful activity. Proceeds are things gained from illegal acts, like money or assets bought with crime-related funds. Note that the definition, though technical, is conceptually easy to follow. Money earned from unlawful activity can be used to purchase other assets. For example, drug money is used to buy a car. The definition of proceeds includes property that increases in value because of unlawful activity, or includes decreases of a debt secured against a property, for instance, like a mortgage, because of the unlawful activity. In these cases, the director will follow the money. Instruments are things used, including places, to commit illegal acts, like vehicles or buildings. The definition of instruments includes a number of elements, such as property that is used to engage in unlawful activity or is likely to be used in unlawful activity. As in, past use might be sufficient to support a forfeiture order, like a history of reckless driving that could result in bodily harm. The purpose section is similar to many other Canadian jurisdictions with civil forfeiture legislation. The purpose of civil forfeiture is to take or remove the unlawful profits and make crime unprofitable. The intent is for people who engage in unlawful activity to not keep the resulting property, while also preventing property from being used to engage in certain unlawful activities. There are two types of proceedings under the legislation. There's both the court civil forfeiture proceeding and the administrative forfeiture proceeding. NWT's bill includes both, similar to Alberta, Ontario, Manitoba, and BC, Saskatchewan, Quebec, and Nova Scotia. All of these jurisdictions have both types of civil forfeiture. Only New Brunswick and Nunavut don't have an administrative forfeiture and rely exclusively on the court process. Court-based civil forfeiture proceedings are all civil law proceedings. The rules of procedure, the standards of evidence, and the standard of proof are all civil and being on the balance of probability. The director will start a proceeding, and if satisfied that the property is a proceed or an instrument or both of unlawful activity, the proceeding will start in the court. There are interim orders contemplated in the legislation. They are an important aspect of the Act because it gives the director the ability to freeze assets pending the outcome of a court proceeding. The Act gives the court a range of ways to preserve the property. This is critical because illicit assets can disappear quickly. These orders can also be made without notice for a maximum of 60 days. Interim orders can be challenged, but assuming they stay in place, litigation moves to the next phase where pleadings are exchanged, witnesses are examined, and ultimately a forfeiture hearing is held. Under an interim order, the director can request that the court assign duties to the asset manager. The asset manager has a range of powers under the Act, but in the context of an interim order, the asset manager's authority must be included in the court order. In a simple case like a seizure of cash, the asset manager may only need to deposit the money into an account to safeguard it. In more complex cases involving homes with tenants or businesses, the court will craft the order to deal with the unique circumstances in the case. Unless it is clearly not in the interest of justice, the court will likely make an interim order. If on the balance of probabilities, the property is a proceed or an instrument of crime, and where there is no protection or order protecting a third party, the court must order forfeiture. The Act does allow the court to not make an order if doing so is clearly not in the interest of justice. Protection orders are also available under the Act. They are a safeguard to protect the interests of those who are not involved or complicit in the unlawful activity. The Act allows anyone with an interest or potential claim to a property to intervene and protect their interests. The person seeking the protection order bears the onus of proving they are entitled to one. Claims that lack evidence or credibility would certainly be denied. The court decides whether it would be in the interest of justice to protect the claimant's interest. The Act includes a list of presumptively protected interests: banks, insurance companies, and governments, including municipal governments. These institutions must hold a prior registered interest in the property to be entitled to the protection order. This class of institution can be extended by regulations which is where Indigenous government organizations and Indigenous governments could be added as land claim and self-government agreements are signed. The second class are protected under the land title system. The other is administrative forfeiture. Other provinces began adopting administrative forfeiture because they were faced with an increasing number of default proceedings in which people didn't show up for their court hearing. Adding the administrative forfeiture procedure allowed them to reduce the use of court time and lowered the cost of the proceedings. For example, in our discussions with British Columbia, between 2011 and February of 2012, 134 administrative forfeiture cases were brought. The legal cost savings for these cases was estimated at $1.1 million. Of those 134 cases, 25 were disputed, 46 were concluded, and $367,000 was recovered. The process on administrative forfeiture is as follows. The director can forfeit cash and personal property if it is worth less than $125,000. Anyone with an interest in the property can intervene and move the proceeding to the court system. The director must be satisfied that the property is a proceed or an instrument before commencing an administrative forfeiture. To start the process, the director must first file a notice under the Personal Property Security Act, give notice to the interested person, and post a public notice. If the director doesn't have any information about the person's address, they do not have to give personal notice, though public notice will still be required. After property has been forfeited, a person who claims an interest in the property and who would like to be reimbursed has up to 2 years to start a court action against the director and government of the Northwest Territories. For the conduct of proceedings under civil forfeiture, the Supreme Court rules apply to all proceedings under the Act. During a proceeding, the director can refuse to disclose sensitive information, either in examination for discovery, in an affidavit, or at a hearing, if it is to protect the identity of a confidential informant, a person's safety, or a police investigation. The NWT's Act is based on Manitoba's and BC's in respect of legal expenses, in that the Act is silent, which means that assets cannot be accessed for legal expenses. After a civil forfeiture case is over, if the director is unsuccessful, the respondent could file a motion for costs, but the money would not be available for the legal expenses. The standard of proof and general use of presumptions in the Act. The general standard of proof in forfeiture hearings is the balance of probabilities, which applies to findings of fact and the discharge of presumptions. In a proceeds case, for example, the director must convince the court that all or part of the source of the property, cash or other assets, lies in unlawful activity. The director does not have to link the property to specific unlawful acts to make the connection. Instead, the director can show that the property that was derived from or its use relates to unlawful activity or patterns of unlawful activity, which should be sufficient proof to convince the court. If a court has already made a finding on a higher standard of proof, such as beyond a reasonable doubt in a criminal matter, then this proof in the civil forfeiture that a person committed the offense exists, and no need to relitigate the issue or a lower standard of proof is necessary. Courts have rejected that the civil standard of proof violates Section 7 of the Charter, life, liberty, and security of the person, ruling that Section 7 doesn't protect economic interests. Another notable provision in civil proceedings is that there is no automatic right to pause or stay a civil case, even if there are related or parallel criminal proceedings. The Act, however, allows a court to delay civil forfeiture proceedings to permit prosecution of offense to be completed if it is to protect a victim or if it's in the interest of justice generally. The Act includes a presumption related to criminal organizations, adopting this definition from the Criminal Code. Proceeds and instruments in cash are also defined. Presumptions create an inference that the property was sourced from unlawful activities. If a presumption is raised, the respondent must provide evidence of the contrary to overcome the presumption. Property owned or possessed by a member of a criminal organization or a corporation, if a director or officer of that corporation is a member of a criminal organization with a significant ownership in that corporation, it is then presumed to be a proceed of unlawful activity absent evidence to the contrary. Property that is transferred for significantly less than its fair market value to a person or corporation with ties to criminal organizations is also presumed to be a proceed. There are also presumptions related to instruments, like vehicles, defined as conveyances under the Act. A vehicle or a conveyance will be considered an instrument if restricted firearms, controlled substances, aftermarket hidden compartments, or stuff related to trafficking is found inside the conveyance. There's an additional presumption that a vehicle is an instrument if a person refused to stop at the direction of law enforcement and where serious bodily harm could have resulted from the person fleeing. A building is presumed to be an instrument if a controlled substance in an amount consistent with drug trafficking is found in the building. Property is presumed to be a proceed if a person engages in unlawful activity that likely gave them a financial benefit and then later acquired or improved a property or paid a debt down with this proceed. Cash is presumed to be a proceed if found near a controlled substance, such as drugs, if it's packaged unusually or mailed or shipped with no return address or has a false name or address on the return address, or the person who sends cash for shipments doesn't provide their name or address or provides a false name. After successful forfeiture proceedings, the property that is not already in cash form is generally sold and converted into money by the asset manager. Once property is sold and converted to cash, the money is deposited into the Civil Forfeiture Fund, a special purpose fund created under the Act. Money can only be distributed from the fund in the way stipulated as outlined in the Act: to pay costs of the forfeiture proceedings, to pay costs of managing or selling any property, compensate victims, support programs and services that benefit victims, fund crime prevention and crime reduction initiatives, including law enforcement, or support other community safety programs as prescribed by regulation. In cases of theft, eligible victims will be able to seek compensation if they didn't directly or indirectly participate in the commission of the crime. The process for seeking compensation and the method for calculating compensation will be set out in the regulations. Other administrative matters. The Act is built around the statutorily created position called the Director, who initiates most steps taken under the Act, like applying for interim orders to preserve property and applying for final orders to forfeit property. The Director is also responsible for managing information and property under the Act. The Act also creates the role of Asset Manager, who is responsible for possessing and managing property that is subject to an interim or final order. The Asset Manager has the discretion to manage, sell, or dispose of property in the manner the Asset Manager considers appropriate, subject only to any stipulations in any court orders. More information on the provisions and the annual report in the next two slides, which are also the responsibility of the Director and the Asset Manager. Information provisions. The Act gives the Director the statutory right to collect information. Once a civil forfeiture file is referred to the Director from the RCMP, the Director may need to gather more information. It is important to note that the Director acts independently from law enforcement agencies, as in, the Director cannot direct the RCMP to investigate civil forfeiture files. Therefore, the Director might need to gather additional information independently to support a civil forfeiture case. Information can come from a person who has a registered interest, a public body such as a department, agency, or municipality, or other source like a member of the public. Under the Act, those public bodies are in turn authorized to share information with the Director, except if the information is subject to solicitor-client privilege or if evidentiary rules to protect an informer's identity are in place. The Director is also empowered to enter into information sharing agreements with law enforcement agencies, which will include the RCMP. Those agreements enable the agency to provide the Director with information to consider for civil forfeiture proceedings. The Director also has the ability to enter into reciprocal information sharing agreements with other jurisdictions, allowing the Director to share information with other civil forfeiture programs if the Director is aware of property now located in another jurisdiction that was derived from unlawful activity. The annual report. After each fiscal year end, March 31st, the Director is required by the Act to provide the Minister with an annual report. Both the director and asset manager are responsible for preparing the report, which includes information about the number of forfeitures, the total amount of money received from forfeitures, and information about how the money in the fund was used. The annual report may include other information requested by the minister, and the minister would then table the annual report in the Legislative Assembly. There are other miscellaneous provisions in the Act, including limitations and limitation periods, offense provisions, and limitation of liability provisions. Under the Act, there is no limitation period to commence proceedings under Part 2 and Part 3. Those are the civil forfeiture and the administrative forfeiture sections. This means that the director may start an administrative or court proceeding at any time. The Act applies retroactively, so property that is a proceed or an instrument can be pursued even if the unlawful activity took place before this Act comes into force, and assuming it does. There are offense provisions under the Act and penalty provisions related to the director's power to collect information. It will be an offense to give false information to the director, to fail to comply with a request for information from the director, and to disclose that the director has requested information. Penalties include fines up to $10,000 or imprisonment for up to 6 months for individuals, or fines up to $25,000 for corporations. There are liability protections under the draft bill. The Act includes limitation of liability provisions, which will protect the director or a person operating under the director's direction while performing duties or exercising a power under the Act. This protection from liability does not extend to any acts or omissions that are committed in bad faith. There are also several regulation-making powers in the bill, some of which will be developed before the Act comes into force, like how to compensate eligible victims under the Act. And this concludes our presentation. Thank you, Madam Chair.
Thank you. Thank you, Minister. Committee, are there any questions? MLA Morgan?
Thank you, Madam Chair. I do have so many questions. This is a fairly new concept to me. Where should I start? Okay, maybe I'll start with one example that you gave, and this was related to slide 7. And the example was if the person has a past history of unlawful behavior, such as reckless driving, a history of reckless driving, then that could be grounds to seize, I think, a vehicle in this example or this scenario that was cited. Can you explain in this example or this scenario, what is the unlawful activity? Are we contemplating that if a person is driving recklessly or has in the past, that without needing to charge that person or take them to court, you can just take their car away? Is that the scenario, or is there some other illegal activity that has to be involved here where the car was obtained through illegal activity in order for it to be seized? Or is it simply like, you were using this car for illegal things like reckless driving, therefore we're taking your car away? Can you just explain that scenario, how it would work? Thank you.
Minister?
Thank you, Madam Chair. I will pass that to Assistant Deputy Minister Patzer. Thank you.
Please, go ahead.
Thank you, Madam Chair. I think what the example was meant to portray was that if the director could prove that the instruments was going to be used in an unlawful activity, then the asset could be seized under, or I guess the administrative process under the civil forfeiture legislation could be utilized. And I'll defer to Ms. Schmaltz as well to make sure that I've got that right, Madam Chair.
The examples I've been giving.
Wait. Okay, thank you. Yes, please, proceed.
So the examples I've been given by just reading about civil forfeiture and speaking with the other jurisdictions is, for example, there's a history of like drunk driving charges. So I'm not sure, likely if someone had been convicted and it's a repeated offense, and then say they're charged again, and that they're using their vehicle after they're driving, it could be grounds. I'm not saying it would be seized and then go through the civil forfeiture process, but that could be a possibility.
Okay, thank you. Ms. Emily Morgan, do you have a follow-up question?
Yes, I have so many questions. So in that example, or in that case, is there a minimum threshold for how serious the unlawful activity has to be? I mean, there's lots of things that are unlawful, including like trespassing, or like that many of us would be like, okay, it's against the law, but do you deserve to have your car taken away for that? Like how serious or how frequent, or and I don't know how you prove that someone is going to use that thing in the future for something illegal, therefore you take it away first. I don't know how anyone can prove what someone is going to do in the future. But I wonder if you can explain whether there's some defined threshold of how serious is the illegal activity, or what type of illegal activity it has to be in order to go to the rather drastic step of taking a valuable item away from someone without even charging with them with a crime. Thank you, Madam Chair.
Minister?
Thank you, Madam Chair. I will defer that to Adrian, please.
Please proceed, Ms. Schmo.
Yes, thank you for your question. So I guess to start, the threshold, sorry, I'm kind of blanking on the question at the moment. Yeah, so unlawful activity in the Act is defined as like any offense under federal, territorial, or the legislation of another jurisdiction if there's an equivalent offense. So likely it's going to be if it would be a criminal offense. Like that's often, most frequently, the types of unlawful activity that you see. So it's also not about the person in the case, it's about the property. So if there's circumstances that suggest that property is either a proceed from crime or was used to commit a crime, then that would be enough, but that person isn't, like, they're not being prosecuted in this context. As well, there's always on each case, if it's challenged and it's going through the court process, the judge decides whether the order of forfeiture is in the interest of justice. And so in case law, that is, the court will look at what is fair and equitable in the circumstances. So if there's repeated patterns of, I guess, a pattern of, or history of committing similar offenses, then the court might look to that. But if it's just a one-time offense, the court might take that into consideration of whether it's in the interest of justice to forfeit the property.
Okay, thank you. Emily McNeely, do you have a question?
Thank you, Madam Chair, and thanks to the Minister and staff for this presentation. What really caught my attention here is on slide deck 19, limitations periods. I think it's a good piece, and I just want clarity that it says the Act applies retroactively, so property that is a proceed or instrument can be pursued even if the unlawful activity took place before the Act came into force. So we could execute a process prior to this legislation coming into force? Like, let's just say last fall. Can we reactivate a situation from last fall's activities? Thank you, Madam Chair.
Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer, please.
Mr. Patzer, please proceed.
Thank you, Madam Chair. What that provision is meant to address is the situation when this act, if passed by the Legislative Assembly, for example, next year, in your example where the proceed of crime or whatever is being looked at from an offense that occurred last year, the answer is yes. This act would allow the Director of Civil Forfeiture to take action against that property.
Okay. MLA McNeely, do you have a follow-up question?
Yes, and I think we all understand, you know, the need for the scan legislation and to give it more publication. Was this bill consulted through the UNDRIP compliance with the Council of Leaders, for example? So you want to bring more exposures to a larger crowd. So was the consultation process done with example, Council of Leaders? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. No, there was just a public consultation in the development of this piece of legislation. Thank you, Madam Chair.
Okay. You okay?
I am okay for now. Thank you, Madam Chair.
Okay, thank you. MLA Nersu, do you have a question?
Thank you, Madam Chair. Thank you for your presentation. My question is similar to Mr. McNeely and limitation periods. Because when I think of civil forfeiture, I think of drug and alcohol activity. And that's been ongoing for years in my community. I can, you know, these people have benefited. You know, a lot of people walk around saying that these guys don't even have to pay for their vehicles. And yet, people who work are making payments bi-weekly and, you know, just getting by. And yet these guys, these people that are, these known people, you know, they're well known in the community. But for some reason, the RCMP can't do anything. They haven't laid a charge of bootlegging for as long as I can recall. And they've confiscated alcohol. And, you know, I was just thinking about, you know, how long can this this be retroactive to a case? Maybe the RCMP are building a case against these individuals. I'm not sure, but I've heard that they've been taking alcohol away from the same people, using the you know, the municipal bylaws, saying that they're only allowed so much to come into the community, and that's why they've been confiscated. But I don't know if the RCMP is using this, if they can use this as building a case to, in the event that when and if this legislation goes through, how far can this civil forfeiture's limitation period go back? Because, you know, people are still benefiting from it, and it's not something people like seeing, but it's out of their hands. But how long can they this retroactive or limitation period go back in time and be a useful tool to confiscate vehicles, homes? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. And MLA Nersu, I think this, you know, what you describe here is really a lot of the intent of what this tool is designed to do, is to disrupt and discourage the criminal activity. You know, so I will pass to Assistant Deputy Minister Patzer for the technical detail. Thank you, Madam Chair.
Okay. Mr. Patzer, please proceed.
Thank you, Madam Chair. There is no limitation period on how far back. But practically speaking, of course, we have to keep in mind that the more dated the alleged criminal activity, the more difficult it becomes or would become for the director to actually prove that there was criminal activity and be able to seize whichever asset was used in the performance of the criminal activity. But to answer your question, there is no limitation period as to how far back this can look retroactively.
Okay, thank you. Mr. Nursu, do you have a follow-up question?
Yes, thank you, Madam Chair. Okay, in the same line, there is, people, like I stated, benefiting from this illegal activity, and if there was this tool being used against an individual, saying that everybody in the community knows that he or she is bootlegging or selling drugs, and if you're going to use this tool to confiscate vehicles or houses or anything of that matter, with the, using Revenue Canada tax purposes to see if that individual did work during that period of time that he said he or she bought this vehicle or something or house, to see if that, was he or she really working at the time to purchase that stuff. Would Canada Revenue Agency be in play at that time too? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer.
Okay, Mr. Passer?
Thank you, Madam Chair. I think the answer to your question is that yes, the Director of Civil Forfeiture does have the authority or the power under the legislation to compel information from various parties, including the RCMP, although that is not so much a compel. The way we envision this rolling out is that there would be information sharing agreements or memorandums of understanding with organizations like the RCMP, where we would share information with them and they would share information with us in order to get at the crimes that were taking place and, make the assumptions that, or find evidence of the assumptions that you were referring to, like somebody who's driving a brand new vehicle but hasn't worked in the past several years.
Okay. Thank you. MLA Yakalaya, do you have a question?
Yes, and thank you for the presentation. My question is, what oversight mechanisms exist for the Director of Civil Forfeiture decisions? Who reviews the director's actions to ensure they are not being misused? Thank you.
Thank you. Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer.
Mr. Patzer?
Thank you, Madam Chair. At the end of the day, it will be the court. I mean, the director has the discretion about whether to bring a matter before the court or proceed with administrative proceedings under the legislation. But at the end of the day, the court has to be convinced that, in the interest of justice, an order should be made of forfeiture. Thank you.
Thank you. MLA Yakalaya, do you have a follow-up question?
Yes, I do. What is the rationale for creating two positions under Bill 45? None of it has only one position, but yet in the Northwest Territories here, we have 33 communities that have to be. How is that going to work? Thank you.
Okay. Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer.
Mr. Patzer?
Thank you, Madam Chair. In the legislation, there are two statutory officers that are created that have different sets of or types of duties under the legislation. Operationally, I don't know whether, when this legislation is implemented, whether that be one person wearing two hats or two people wearing each different hats. That's an implementation question that'll be answered in due course. Thank you.
Okay. Thank you. Mr. Tester is not online. Okay. Okay, I do have a question too as well. In your presentation, you did mention the mortgage, like against debt secured against mortgage, like property against properties like mortgage because of unlawful activity. So I'm just wondering, how would this apply to people living in a public housing unit with housing arrears and and paying off the housing arrears, you know. I know that we have issues in the Northwest Territories, and many of the public housing units are government of the Northwest Territories properties. And, yeah, we do have issues with arrears, and so I'm just wondering, like, how would it apply this? Because it's not a mortgage, but it's a housing arrears. Thank you.
Thank you, Madam Chair. Madam Chair, in that instance, it would be treated in the same manner. The intent of the legislation that it is, if the proceeds of crime are used to pay down a mortgage or pay down a debt, it is considered the use of the proceeds of crime for the betterment of the individual. Thank you, Madam Chair.
So if this law is passed, can it be retroactive, like to go back and, you know, with that directive, follow the money? So I'm just wondering, because if it will, I know there are, you know, I'm sure we all know, just like my colleague nurse who said, you know, we all know known people. And because, well, you know too, you have people living in your area in public housing unit, and people are working, you know, they can't travel all the time, and then some people, they have a lot of, you know, personal items we can see. So I just want to know if to follow the money, I just want to know if this legislation will go back and do something or reinvestigate or investigate. Thank you.
Thank you, Madam Chair. Yes, the answer is yes, Madam Chair. There is the ability within the legislation to go back and, as you say, follow the money. So that is something that the director would be able to pursue. Thank you, Madam Chair.
Okay, thank you. Okay, we still have second set of questions to ask. We still have time, so MLA Morgan, do you have a question?
Yeah, thank you, Madam Chair. I have several more questions. Okay, one is, so when there are goods that are seized, not just cash, is it the role of the asset manager to sell those things to get a cash equivalent? To then put those proceeds into the Victims Assistance Fund, and are all the things eligible to be sold? Like, I could see perhaps if you seized a car, maybe you sell that car and get cash and put it back into the system. But if you're seizing guns or drugs that are worth something, but like, is the asset manager going to go out and sell a bunch of guns to put money into the system? Like, how does that work in terms of if you're seizing property that is associated with crime or unlawful activity? Yeah, do they just keep it indefinitely, or they sell it, and what do they sell? Thank you, Madam Chair.
Thank you. Minister?
Yeah, thank you, Madam Chair. So right now, that level of detail is not described in the legislation. That's something that would be developed when the bill passes, and it would be part of the next step into the process. So it would be speculative of me to attempt to answer that at this time. Thank you, Madam Chair.
Okay. Thank you. MLA Morgan, do you have a follow-up question?
Yeah, thank you, Madam Chair. So noting, you know, we have some information on what's been done in Nunavut, and for some reason, my notes say that they only seize cash instead of property. But, okay, so they're only dealing with cash, but in the last 4 years, or in a 4-year period, they've collected about $50,000. So if we're contemplating establishing 2 new positions to, you know, manage and implement this piece of legislation, looking at what they've managed to collect in Nunavut, like the proceeds associated with crime doesn't come near to like breaking even in terms of what the cost of implementing this program actually is. Is it your intention that this program would pay for itself in terms of collecting enough proceeds of crime that that it would make it financially worth it to the territory to do this? Or is that, is that a consideration? Do you have an expectation this program would pay for itself, or is that not a consideration? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. Madam Chair, I think this program is designed to be a tool that will deter the drug trade and criminal activity in the Northwest Territories. I don't think that the conversation around the cost of this was necessarily looking at the recovery through the process of what, the program costs. We deliver many, many programs across all of government that essentially are an outlay of resources by the GNWT to provide a service to the territory. And this program, like many of those, would be the same. The idea here is to provide tools that will deter activity, make illegal activity unprofitable, and ensure that there are ways to recover the proceeds of crime and redirect them to social programs to support victims, to support policing actions, to support community programming. I think that, as we move these forward, and I really would like to have this on the record, I've visited many, many small communities I've talked to. I would say every leader from a small community across the NWT, and we hear the same message from everyone, that drugs are destroying our communities. Crime is destroying our communities. And so we need to provide the tools in the system that allows us to disrupt that activity. It's a very profitable activity. And this is our way as the NWT. This is an area in civil law that we can make a difference. And that's what we're trying to accomplish here. Thank you, Madam Chair.
Okay. Thank you. Thank you, Minister. MLA McNeely, do you have a question?
Thank you. Thank you, Madam Chair. My question is designing the office and the operations and putting the budget together. I guess that's going to be the next step after legislation, but there could be considerations to drafting a model of operations with a budget. And I'm hoping the minister would take that into account, and is there going to be sufficient funds for this this budget here for traveling? We represent 33 communities, and as we all know, all of them are facing drug issues and problems. And I would like to see sufficient budget in there. What if we get a phone call there from the leadership in Fort Good Hope? Then there's monies or funds or resources to support that. So I just want to make that known and ask the minister if sufficient funds are going to be there to support this office. Thank you.
Thank you. Minister?
Thank you, Madam Chair, and I think that the development of the implementation portion of the legislation would go forward like all other programming. We would take our, what we see as the needed resources forward through the budgeting process, bring it to the Assembly to allow that conversation to happen like we would with all other programs. Thank you, Madam Chair.
MLA McNeely, do you have a follow-up question?
Thank you, Madam Chair. Yes, my follow-up question is, some jurisdictions ensure that disbursement from their civil forfeiture funds target Indigenous-led healing initiatives or are aligned with Indigenous values and ways of being. And this question is similar to Ms. Morgan. Can the minister explain whether disbursements from the NWT's potential future civil forfeiture fund will include aspects like this? Redirecting funds to support the Indigenous healing, I would say.
Thank you. Minister?
Thank you, Madam Chair. I will pass to Ms. Schmalz.
Ms. Schmalz?
Yes,
please go.
thank you for the question. So yes, initiatives like that could be supported under the legislation. So the way it's described in the legislation is it can be put towards, community programs, and it's about public safety. And in talking to other jurisdictions, they support a wide range. They actually sometimes, I think it's Alberta, they produce a list online of all the different organizations they support. Other places have bought camping gear, for example, for youth to get out on the land. So I would say that as well within the scope of the purposes to which the funds could be put.
Okay. Thank you. Okay.
I was just going to say, even though that's not specifically listed, that is within scope.
Thank you very much.
Okay, thank you. George, do you have a, MLA Narcy, do you have a question?
Thank you, Madam Chair. My question is around so-called innocent individuals who live in the household, whether it's a public housing unit, because when you're living in a public housing unit, you sign a tenants agreement, and any illegal activity, you're kicked out of the unit. But I haven't seen that. Haven't seen any of that done. But it's innocent people like children, elders who have no knowledge of these criminal activities. I'm always going to refer to bootlegging because that's my biggest problem. You have alcohol, you're going to have crime. And we have a lot of these people that benefit from bootlegging. What about innocent people like children and elders who are residing in the same unit, whether it's a private home or a NWT housing unit? Are they allowed to stay in the unit? We got a big housing shortage. We have a lot of homelessness. And also, if it's a married couple or a common law couple, and say that everything is in one person's name, are two of them held liable, responsible for this criminal activity, or is just one, or how would that work? Thank you, Madam Chair.
Okay. Thank you. Minister?
Thank you, Madam Chair. I will pass to Assistant Deputy Minister Patzer. Thank you, Madam Chair.
Mr. Patzer?
Thank you, Madam Chair. Generally speaking, I don't think a housing unit owned by Housing NWT would necessarily be considered a proceed or an instrument of crime, but if the housing unit...
Well, when you're signing...
Mr. Please
Okay,
proceed.
when you're allocated a unit, you sign a tenants agreement, and in that agreement, it says that if there's any there's any unlawful activity, you're going to be kicked out. So if you are with this bill, say you are convicted of unlawful crime in a public housing unit, and housing unit comes and says you are convicted of this, and you sign this agreement that now you have to leave that unit, and the elder and the children may be on that lease agreement. So it is a concern. I'm sure other jurisdictions may have dealt with this. I know Yukon did. I believe. It's just something that that is, I don't know if it's been looked at, but also, one spouse over the other, will both of them be held responsible for this activity because they're both maybe benefiting? I don't know. I mean, just a question. Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. I'll pass to Assistant Deputy Minister Patsy. Thank you, Madam Chair.
Thank you, Madam Chair. There are provisions. First of all, the legislation is targeted at assets and not the individuals. And the director is looking to disrupt crime by taking the assets that are used to perform crime, or monies that are used to support crime or profits from crime. In the case in the example you're providing, whether it's a housing unit or a place that's owned by an individual, there are provisions under the legislation that allow an individual to come forward to the court and get what's referred to as a protection order under the court. So if there are, if I can put it this way, innocent third parties that are going to be impacted by an application that directors made, they can come forward and make their case to the court and say, hey, I have an interest in this unit, or I have an interest in this, whatever the asset or property is, and they can have the opportunity to appear before the court and make their case, and the court will issue a protection order indicating that there are individuals other than the person who is, if I can put it this way, guilty of the offense, and they will be protected under the legislation. There are avenues under the legislation where they can apply for protection of their interest.
Okay, thank you. MLA Nursu, do you have a follow-up question?
One final question. Passing down ownership of a vehicle to a teenager who just got his license because, they may be due to this bill, it may be confiscated in time, but, that's just more of a comment. My question is, in terms of going through the court system or dealing with the director, if you had assets taken away and a vehicle and you want to contest it, will these people be able to get the services of legal aid? Or thank you, Madam Chair.
Okay, thank you. Minister?
Thank you, Madam Chair. That's not contemplated at this time. Thank you, Madam Chair.
Okay, thank you.
No, not at this time.
Okay. Okay, next we'll go to Ms. MLA Yakalaya. Do you have a question?
Yes, yes, I do, Madam Chair. Thank you. Bill 45 notes that a proceeding is against property, not against the person. The court does not require a criminal conviction to find that a person participated in unlawful activity on a balance of probabilities. Bill 45 also clarifies that the court does not need to find that the property was acquired through any specific unlawful act, only that it is connected to unlawful activity in general. In the development of Bill 45, did the minister consider including that a criminal conviction must occur prior to the forfeiting of property to ensure that no one is unjustly involved in the forfeiting of property? And could the minister clarify how the bill addresses concerns about due process and preventing an overly broad application given that these property owners have not yet been convicted of an offense? Thank you.
Okay, thank you. Minister?
Thank you, Madam Chair. So I'll speak to the first part. The intent of the Civil Forfeiture Act is to address the property that is related to the activity. The activity is not based on whether or not a conviction occurred in the court. So if, for example, there was a large amount of cash, some narcotics, a person was arrested for whatever reason, a technicality perhaps, that case was unsuccessful in the court system, the Civil Forfeiture Act will allow the ability to go after the cash that is, associated with the proposed activity. That's the intent here, so I think a lot of the, I'll leave my comments at that and pass to Assistant Deputy Minister Patzer for the second part of the question.
Thank you. Mr. Patzer?
Thank you, Madam Chair. I think, if I recall correctly, the second part of the question is whether a criminal conviction was required first, and I think the minister indicated no, a conviction is not required. All that's required is that the director prove to the court that the asset or proceeds were associated with criminal activity. And then, if so, then a forfeiture order of the proceeds would issue to the GNWT.
Okay. MLA Yakalaya, do you have a follow-up question?
Yes, I do. Can the minister explain how and if the legislation will consider hardship relief if the forfeiture would cause significant harm to those who are innocently involved? Thank you.
Thank you. Minister?
Thank you, Madam Chair. Yes, Madam Chair. Very similar question to MLA Nersu's earlier question. There is the provision within the legislation for a protection order in that case where the affected person could come forward to the court and pursue a protection order. Thank you, Madam Chair.
Thank you. Okay. MLA Morgan, do you have a question?
Thank you, Madam Chair. So I hear loud and clear that the purpose of this legislation is to disrupt drug crime, and people are also talking a lot about like bootlegging and alcohol-related crime. Was it considered that you could specify in the legislation that this is meant to apply only to drug-related crime or alcohol-related crime, if that is in fact the purpose that is being stated here? My concern is that right now it's so broad that it could sort of catch up in its net or in its web people doing other things that we might not consider to be all that serious, but it's technically unlawful. Like, and I don't know what exactly is included, but you run a red light, you do things that are like, that was a bad idea and like maybe reckless, but it's not, most people would not consider it in the same league as drug crime, drug dealing. So is it possible to specify, or did you consider specifying in the legislation that this applies when we're dealing with drug or alcohol-related crime, or at the very least, criminal offenses? Like, it was stated earlier that it's likely or often might be a criminal offense, but it doesn't seem like that's mandatory. It could be any other kind of offense. Did you consider specifying that it has to be a criminal offense that the property is associated with? Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. I don't think we looked at it from that perspective. I think the intent is that the court will be the keeper of the gate, if you will, to determine that what is being brought forward is in the interest of justice. So I how to say it, the director would not likely bring forward something that would exercise discretion in what would be advanced under this legislation. So, yeah, thank you, Madam Chair.
Okay. Thank you. MLA Morgan, do you have a follow-up question?
Yes. I mean, personally, I'm not greatly comforted by the idea that this would be at the discretion of a public servant. But and you're mentioning a lot that the court needs to decide, the court will hear the case of different people involved, but there's also an option for administrative forfeiture where it doesn't go to court, right? You explained that as long as the property or the value of the cash is less than $125,000, which is a lot of money still, it doesn't ever have to go to court. The director could just do the thing and someone could the director could seize the thing. Someone could put in their little application saying, no, wait, it's a misunderstanding. But this is not going through the court, it's just going to the director's office. So can you explain, in the case of administrative forfeiture, whether it's possible that it could just go forward without involving the courts at all, or is there always going to be some kind of court oversight? Or, sorry, not oversight, but involvement. Thank you, Madam Chair.
Okay, thank you. Minister?
Thank you, Madam Chair. I'll pass to Assistant Deputy Minister Patzer.
Okay, Mr. Patzer?
Thank you, Madam Chair. The answer is if somebody, during the administrative process, somebody objected during the process, the matter would divert to a court process. The administrative process was simply put there because the experience in other jurisdictions was that if there was a drug bust, a wad of cash was seized, notice was given to the individual, it went through a court process. Oftentimes, they didn't even show up because they knew they weren't going to be able to defend or justify that the cash was used for anything other than crime. So that's when they came up with the administrative process that wouldn't occupy the court's time. But if somebody did show up and say, hey, either I have an interest in that cash, maybe they weren't charged, or maybe for whatever reason they're an innocent third party, or if the individual who the cash was seized from objects in any way, shape, or form, then the process would divert to a court process.
Okay, thank you. Okay, one more, and then we're going to, yeah, go ahead. Please proceed, Ms. MLA Morgan.
Thank you, Madam Chair. So in that last case, so someone would have to object, and there's like a time period, right, where they have to make their objection or but what if it was cash that was seized and someone else had a legitimate interest in that cash that wasn't the person who was like physically there when it was taken, but they didn't hear about it, they didn't know, and then that time period passed and they didn't have a chance to object or sort of make their case or say, wait a minute, that was my money, that was my cash, and you can't, but then the time passes, they didn't know, it never went to court. Like, is there a scenario, how do you know to notify all the people who might have an interest in that cash? It's not like the cash has like a little name tag on it or something, when it's just an administrative procedure and it's not going to court. Thank you, Madam Chair.
Thank you, Minister.
Thank you, Madam Chair. I'll pass to Assistant Deputy Minister Patzer.
Mr. Patzer?
Thank you, Madam Chair. In the administrative process, there's an obligation on the director to not only serve the individual whom he or she knows has an interest in the proceeds, but also to any other individuals who may have an interest. And there's also an obligation to post in a public place, I believe it's on a website, I can't recall exactly what the language used in the legislation is, that these processes are taking place. And if after all of that takes place, this third party doesn't get notice that this administrative process has happened, that there's been a forfeiture order, there is still the opportunity for that individual to sue the GNWT under this legislation and to prove that the proceeds do in fact belong to them.
Okay. Okay. Okay, thank you. MLA Nurse, do you have a question?
Yes. My question is in reference to, you find large amounts of money in a unit, in a house. Outside they have a vehicle, they have large ticket items, ATVs, which may come over to the sum of 125,000, and another avenue is used in this. Where is it? Not the administrative system, but the other one. How would they go about looking at records or anything of from the financial institutions? How does that go about? Do they, or is there some mechanism where they can go to each financial institution and say that they have a case against this individual or individuals, and you're looking at freezing their assets? How do you go about finding other sources of of assets that have been accumulated due to criminal activity. Thank you, Madam Chair.
Thank you. Minister?
Thank you, Madam Chair. I'll pass to Assistant Deputy Minister Patson.
Mr. Patzer?
Thank you, Madam Chair. I think that's part of the investigator's primary role as the investigator under this legislation. That's also why we anticipate there will be information sharing agreements with law enforcement agencies such as the RCMP. In addition, under the legislation, the director will have the authority to compel information from certain institutions.
Emily, do you have a follow-up? You're okay? Okay. Okay, if there's no more questions, then I want to say thank you to Minister for appearing before committee today and providing us with the level of detail we need to continue our review of Bill 45, Civil Forfeiture Act. Does the minister have any closing remarks?
Thank you, Madam Chair, and thank you to committee. Appreciate the very detailed questions, and we're very happy to present tonight. Thank you, Madam Chair.
Thank you. Thank you. With that, this concludes this evening's public hearing. Have a good evening.